Thank you, Laura. I appreciate you coming again.
Happy to be here. Thank you.
Let's start with your decision to come to law school. You came to law school at a time when you already had, what, 2 children?
I did.
All right. Tell us about that decision and what it was like to be here and going through law school as a mother of 2 young children.
When I applied to law school, very possibly a postpartum thing, because my twins were 9 months old when I started law school. They're now grown. I'm a grandma. So it worked. It all worked out okay, but it was hard. It was harder than I think I imagined it would be, but in retrospect, I don't have any bad memories of it. The kids, they were little. They don't have much memory of it at all. And I think the way, well, I'm answering a different question and then I'll go back. I think the way that it worked was I decided that law school would be my job. I had left work in the private sector. I had been working for Blue Cross Blue Shield. It was a fine job, but it was not stimulating me. It was not, I knew I wanted to do something more. So I looked at law school like a job. I had someone to care for my children during the day, just like I was going to work, like I was a working mother who would get here early and would stay till about 4:30 or 5. And it didn't matter which classes I had that day. I parked in a carrel that I had camped out for myself from the first day of law school, and that's when I got my work done. And then when I came home, I was able to be with my children, able to be a mom, and then of course they're little, so they go to sleep pretty early, and then I would have the rest of the evening to do what else I needed to do. And as law school, as I got more comfortable with it, the workload, the pace, then I was able to have bigger breaks in the day because you only have a couple classes on some days, and I could take more advantage of that around my children's schedule. But I think that's the way you have to look at it if you have kids, that it's your job. Otherwise, you're going to feel, I think, too divided in 2 different places. But I came to law school. I had done some of the mock trial stuff in high school and something in college. I can't remember anymore. And it was interesting to me. It was, Pat and I were just talking, I don't know if any of you remember this show, LA Law. This is how long ago. It's probably in syndication now. And it seemed like a dynamic, exciting, worthwhile, important way of giving back and supporting yourself. And that's pretty much what drove me to do that. Applied, and I can't say that I spent years and years aspiring to be an attorney, but once I applied and took the LSAT, it was sort of on. It was just moving, and it just happened, and I'm very glad it did.
One of the things that's unusual about your career is that you have worked in specialties that really are not, are different. I mean, you were private practice, you were prosecutor, and so on. And now you're 100% criminal defense. Could you, before we talk about the criminal defense stuff, could you talk a little bit about those other jobs, the other kinds of things that you've done and what they did for the development of your career?
Sure. And this may, I haven't really thought about it until this moment. This is probably related to the answer to the first question, which is I didn't aspire to do a particular thing in the law except to help people. I wanted to be worthwhile, make some difference. So when I graduated from law school, I had the good fortune of graduating high in the class, and I was receiving offers. I know it's very different now. I'm an adjunct professor here, and I know that things are very different than they were in the heyday where law firms were just scooping you up like crazy before you even graduated. I really didn't know anyone, handful of people when we were graduating that didn't have a job before the last semester of third year. All of us were employed. So, and I know it's different now, but then you're kind of juggling offers, and I chose a large firm in Atlanta. It's an international law firm, Jones, Day, Revis, and Hogue, which is really, their home office is in Cleveland, but they're all around the world. And I liked them. I had done the summer clerkship thing with them. And I was going to be in the new associates group, which their acronym was NAG. And that's what you did, is you got there and you nagged junior partners and senior associates for work. You had to get your hours. And to try to test out different areas, I was in the litigation division of the NAG group. So what it did for me, I met some very interesting, bright people. I got to touch a lot of different things in civil work. I did some securities litigation work. But mind you, all that work, when you're working for a large international law firm your first couple of years out, is all done at your desk. You're going through discovery and a lot of research memos. And it was good. It was a good thing. I think that it was motivated primarily by the salary. I was, as you now know, I was at the time a young single mother with 2 children who had just gone through law school, and it was important to me to begin considering how I was going to now move forward. So it was not a bad experience, and I still have friends from there who've done very well, and it was a good fit for them. But I needed clients. I needed some on-the-ground working with the people that I'm helping. It didn't feel that I felt it was worthwhile work, important work, but I was working for Carl Icahn, TWA, and R.J. Reynolds. There was no people that I could associate with. So I ended up coming back to Macon, and I had recently married and come back to Macon and worked for a short time in a personal injury medical malpractice firm, a very good one in Macon. And so I did plaintiff's work. So I went from the defense side to a plaintiff's firm. And that was very interesting. And then I could see people. I could see people that were hurt, and I could make a difference. I could know who I was helping and have that kind of relationship. And soon after that, it's going to sound like I really have stayed in what I'm doing now for quite a while, but I really did bounce around a lot in the beginning. And that worked out okay. I received an appointment as an assistant district attorney at the district attorney's office here in the Macon Judicial Circuit, which is Bibb County, Peach County, and Crawford County. And I worked in prosecuting major felonies for several years there, and I also worked in the appellate division and worked on preserving convictions in the Georgia Court of Appeals and the Georgia Supreme Court. Something that'll make a little more sense as you get a little further through. Wonderful work, important work. I really was proud of what I did. I enjoyed it. I enjoyed the people I worked with. It was emotional issues, as you can imagine. Criminal work is emotional. And then sometime after several years I'd been prosecuting, my husband, who is Frank Hogue, much more of a high-profile figure than me, and so many of you may know who he is or see him on TV. He had been a sole practitioner. He'd been in a small firm, reached partnership, and went out on his own because he very quickly decided all he wanted to do was criminal defense. And it was a perfect fit for him. So we made the decision that I would join with him, and we formed a partnership in '97. And we've been doing it ever since, just exclusively criminal defense work.
Hogue and Hogue.
Hogue and Hogue.
Let's talk about what you do now. And I don't know how to introduce it other than to say, is there a typical day for you? Or maybe one way to think of it is what's on your desk or waiting for you later today.
There are no typical days, but I'll lay out today. When I leave here, I'm going to go back to my office, get a file, and go over to the U.S. Attorney's office where I have a conference with an assistant U.S. attorney in a drug case. I'm out of Athens, Georgia. My client is a four-time, the U.S. Attorney's Office calls him a four-time loser. He's a four-time drug convicted felon. And he's on camera, as clear as a bell, in about 4 or 5 different cocaine and marijuana transactions that involve guns, have a child there while it's going on. And under the federal sentencing guidelines and the United States Code, he's probably, all we're doing is trying to do anything to keep him from going to federal prison for the rest of his life. There is no parole in the federal system. There was no violence in any of these crimes. And so my job over at the U.S. Nobody's clerking or anything. We're all first year, so there's no clerks, I'm not. So my job over there will be to impart some humanity into this process. And also, it's kind of a numbers game in federal drug prosecution, meaning the sentencing range will be guided by the drugs that get attributed. So he's going to have to enter a plea. Literally, he's all over the video, counting and cooking, and it couldn't be any clearer. Oh, and then there's a 3-hour interview where he confesses everything too. So that's going to be a little problematic as well. So we have to, in federal court, the whole deal too is your clients, and I abhor this, but there's a thing called a 5K motion, which is the only way you can get out from under some of the mandatory minimums and these incredibly high lifetime sentences is to provide substantial assistance to the government. I mean, to become a snitch, to become an icky snitch, and just do to other people what they did to you to cause you to be on videotape in his ball cap going like this and making the whole transaction. So that's my morning, probably, to try to get some kind of sentence that gives him any light at the end of the tunnel. In the afternoon, I have a phone conference with my client who is in, I can't remember anymore, I think he's in Hayes State Prison. I represent him on a habeas. He was convicted back in the 80s of a double murder, and he has been in prison now for over 30 years. Yeah. And he's old, and we're doing what we can to try to get him some parole. The double murders it was at the same time. It's a very, very different time in his life, as you can imagine. And he really, though I'm sure that the state doesn't agree with this, he really doesn't pose much of a danger to anyone anymore. All it is you and I and our tax dollars are just keeping him going in prison. But he's a sharp guy, and he's savvy. He's actually has been making investments while he's been in prison. Not sure how all that worked out, but I wasn't involved in that part of it. That led to my involvement because he was able to get us on board for a habeas corpus. There were some issues in his initial conviction that are constitutionally questionable. So I have a phone conference with him to talk about a hearing that's coming up. And then I have to get out today. I have a case pending in the United States Supreme Court where my client was convicted in the Middle District of Georgia of running a pill mill. Have you heard of what a pill mill is? You're a physician and running a pain clinic, and the government's theory is you're just giving out OxyContin-like candy without any exams, and that was the jury's opinion as well. And there was a very discrete issue that went up to the United States Supreme Court in the 8th Circuit. I went up there and watched the argument and then was able to incorporate that into my argument. So I have another brief due to them that we're going to finish editing. That's pretty much today, and it won't be anything like Monday, and it won't be anything like yesterday. So it's not boring.
It sounds like one of the attractions to it. So you represent clients who are accused of drug crimes, murder, child molestation,
Yes.
Kidnapping,
Yes.
theft, Trying to think of it.
Fraud, tax evasion, shootings, stabbings, stalkings, a lot of child porn. It's a very big thing now to prosecute.
Okay. Other than it not being boring, what do you like about it? This is not for everybody, we know that, but it is for you. What do you like about it?
I like that everything I do has an immediate, important consequence, an immediate effect on the lives of the people I represent and the community that I live in. And I think what I like about that's what I like about criminal law. I liked it as a prosecutor and as a defense attorney. What I like a little more about defending is that I think it's a little harder and more of a challenge to summon up the emotion and the empathy. It's, as a prosecutor, the emotions are knee-jerk. They're easy. You can figure them out. You know, a child has been raped, you're outraged and you're angry at the rapist. A person has been killed by a drunk driver, you are angry at the drunk driver. You know, the whole thing. It's just knee-jerk. But to represent and speak for the drunk driver or the rapist, you have to do a lot more work to find the humanity and to empathize, to explain that person's situation, whether it's an all-out defense and that, you know, I've just been misunderstood or I didn't do it, or God help me, I did it, but here's how I became who I've become. And to find in each one of those people the grain of humanity, and sometimes, quite frankly, that may be the best you can find is the grain. But it's an important act of, and I don't refer religiously when I say this, but of grace, of saying we all are worth something. And we all as a community have to take some responsibility for how that guy got to the point where he would murder people for drug money. If you look all the way back and see how we just didn't care or ignored him as an infant until he got to the point where that just was all he knew. It doesn't mean that I excuse what my clients do. It doesn't mean that it isn't disturbing sometimes, many times, what they do. But I think it's a challenging thing, and I hope in some way it translates to the kind of mother, grandmother, sister, daughter that I can be, and friend and neighbor, that I could be able to reserve judgment or knee-jerk judgment on people.
Interesting you say it that way, that because we've talked about this in this class, that it's all one piece. I mean, you are one person. You are the same person in practice as you are in your personal life. And
you know, here's the dichotomy. I run a law firm. I am the managing partner. That means that I'm the one who drew the short straw about 20 years ago, and I do all the books, and I can argue like mad. I go to the U.S. Supreme Court. I can stand toe to toe, but employment stuff, running that. If you have to see everybody from day to day, and this, you could be, it doesn't matter if you're in the law or in any other kind of business, I don't like that kind of stuff. I fret like mad about just getting on an employee for something. I was in somebody's class this week, I think Tracy Delacona's class, to say to a secretary, you're coming late. You're coming in late, and we have to do something about this. I'm paying you because it's my business. I'm literally taking money out of one pocket making it from some client and then taking it out of my pocket to pay a person. And if you're not here, see, I can say it to you really well, and it would make really good sense, and you would think, oh my gosh, you're right. Well, no, I would never say it that way. I would probably go out and buy flowers, and say, oh, we want to thank you for all the great things you do. You're so valuable. You're an important part of this firm. But, it's just this tiny little thing. It's probably silly or, I don't know why. It's just crazy. And I think it's because I want my workplace not to have the tension and the drama of the rest of my career. You go into court, and I'm friends with a lot of my opponents, adversaries, the lawyers on the other side, good friends. But I just want people to be happy, the people that I'm there with every day. So I don't know if I'm the same person everywhere.
Well, maybe a career in human resources.
Maybe
wasn't really
it's not up my alley, yeah.
You talked a minute ago about what you're trying to do for your federal defendant today, which leads me to a more general question. As a criminal defense lawyer, how do you define success for a client? I mean, if success is only a two-word verdict, as you all call it, the not guilty verdict.
Oh my gosh.
If that's the only thing that's success, then it's a pretty dreary life. Success has to mean something else for you.
Yeah.
What does it mean for a criminal defense lawyer?
It means reaching the goals of the representation that the two of you established in the beginning. And that's what you have to do in the beginning. A client comes to me and he's been arrested for child molestation. He could come to me and say, I'm in the middle of a bitter divorce. And that bitch just called the police and said that I have been molesting our daughter because I put in our petition that I wanted joint custody. And she told me, you'll never get it, and I'll make sure of that. So I want you to get these charges dismissed, and I want my name cleared. Or I could go down in my conference room when I see on my schedule that I'm meeting with a potential who's been arrested for child molestation. And I could get down there and his head could be in his hands and he could be weeping and saying, God help me, I don't know what drives me, but I do this. I'm drawn to this, it excites me, it sexually gratifies me, and I know it's wrong. Please, dear God, get me some help and try to salvage my freedom. Now, those are two very different goals of the representation. And if I can achieve what we've sought in those, even if my second guy goes off to prison for some period of time, if it's less than what he would have otherwise been looking at, and he's gotten some way to get some help afterwards, well, then I've achieved that goal. I could be in a death penalty trial, and if I hear the jury find for life, my client will never see the light of day again. Life without the possibility of parole. Incredible success. One of the biggest successes of my life, to have saved a person's life. But to me, the much more satisfying and much more regular kinds of successes have to do with something. When I was here, Jack Sammons was my criminal law.
They've met Jack.
Yeah, and our ethics professor. And he's done some wonderful writing, and he's a scholar in the field. And it was important to him to convey to us that the best lawyer is one who engages their client in the process and somehow moves them along the evolutionary chain a step further. In other words, take some responsibility for what got you here. And try to figure out when you and I are done, whether you hug me and go off in shackles, or you're pissed off at me and you have to go do some time in the county jail, whatever. Whenever we part, that I've left you with something that makes you a little better of a person. Not because of me, but because I forced you to take some personal responsibility to engage in the process of becoming a part of the community by saying, I'm governed by the same laws that you are, and I have to take some responsibility for making this whole place work a little bit better. The difference between personal desires and the needs of the community. Personal freedoms, and then how we make all of this work together. I want to hear my music really, really, really loud at 2 in the morning, and my neighbor wants to sleep. So what do I have to do to say, it can't always be me, but it can't always be him? And how do we reach some compromise here? I think that's the part that's a little, and of course I don't really know whether I've ever done much of that. But all I can know is that I've given it a good shot and hopefully have helped change some people's lives by keeping them out of prison, and that when they then stayed out of prison, their lives were better than they were when they first came to see me.
I'm going to show Jack that answer.
Okay.
He would be proud of you.
Oh, good, good. He's very, very influential.
I assume in the course of your career you've represented folks who did terrible things, maybe child molestation, just as an example. And they were, whatever happened to them, but then they got out and reoffended. Is that true?
Yes.
And maybe if you hadn't been such a good lawyer, they wouldn't have been out to reoffend. Now, that's speculation, of course. But I guess what I'm trying to get to is the question my Aunt Lucille always asked me about criminal defense lawyers, right? How can they do that?
How do you do what you do?
How can you help people who are so horrible?
Well, it's the classic cocktail question, or the question that you get asked every Thanksgiving dinner, or if you're single, if you start dating somebody and you're doing criminal work. God, how can you do that? Why would you devote that much time and energy to such a despicable human being? And the answer is that I'm not really doing it for him or for her. I'm really doing it for us. That I'll just go back to my last example, if the man who comes to see me accused of child molestation, which if it were true, is an awful thing to do to a little girl, a life-changing, forever-altering event that's shameful and awful. If he did it, then he should be punished. And the state ought to be able to prove it. But equally as awful if he didn't do it. It's awful that a wife would make it up, that would help a child to perpetuate it, perhaps even convince a child that it happened, which can be almost as devastating as actually being molested. And to forever put a wedge between a man and his daughter. And to change how the public views him for the rest of his life. So if I tried to decide on my own when I met him if he did it or didn't do it, and then represented him accordingly, meaning if I said to him, well, she says you did it, so here's the plea offer. I think you should take it, because otherwise you're looking at 25 years mandatory minimum without parole, but here's a little plea offer with, maybe 2 years and some probation. I think you should take it. Or we'll go to trial and I'll just try to stir up some reasonable doubt. If I didn't put my heart and soul into it for him, then he's likely, assuming he's innocent, he's likely to be convicted of a thing that didn't happen. But if I'm with him and he says, let's leave about the part because that's a whole ethics issue, but let's assume that the evidence is clear. Now he tells me he didn't do it, but I get the evidence, and his DNA was in her vagina. His sperm was in her vagina. And I'm making this up as I'm going along, by the way. I'm not giving you any actual cases. But, and she's 5 years old. Well, he continues to tell me, I didn't do it, and I want a trial. It's all that bitch is doing. It's always, in a divorce, it's all her fault. I want a trial. If I tried his case with any less enthusiasm or vigor because I had decided he did it, well, then it ruins the whole system. It makes me be the jury. It makes me decide what's right and wrong. And in fact, I'll know and have the confidence of knowing I'm going to give him his full defense. Maybe there's, and I have never done this, by the way, but maybe there's some, she planted it. Wasn't there some crazy movie with Glenn Close or something where she actually got sperm and put it into a dead woman's body, and then they, suddenly the guy's framed. If I've had probably 4 years, I've had no frame. People have never been framed, really, for real. But people say that they're framed a lot. But if I need to perpetuate, if that's the best we've got, I need to give it everything I have so that he is a little bit better, because now he knows that the system worked just as it should, because he'll be convicted. Oh my God, he'll be convicted. I will sleep soundly when the jury finds him guilty, because they should. And I'll know that we danced that story all the way through the courtroom. But I got to tell you, 12 of your peers, after they heard from a lawyer who is good and did a perfectly good job, we sold your best story. Paraded all the witnesses in front of the jury who had to say all these awful things about the mom and how she'd been swearing that she was going to get you. And the jury heard it, and they considered it. I made sure that the law was properly charged, and the jury deliberated and said, no. It didn't give us any reason to doubt that the sperm in her it corroborates her statement that you have been molesting her. Then it all worked right. But if I didn't do that because I found him abhorrent, how have I helped anything along? How could any of you be certain to get a vigorous defense from a criminal defense lawyer if I somehow thought my job was to judge you and to decide whether you did it or not? And what we say in criminal defense as trial lawyers, that the guy whose case is clearly going to lose, I'll take those any day of the week. I'll try those like mad. And that's what most people think is so abhorrent. Oh my God, that's so disgusting that you would try to sell a story that if you were on a jury, you probably wouldn't accept. But the pressure of trying a case when he protests his innocence and it appears that he may in fact be innocent, that's an enormous amount of pressure. And those are the ones that, keep my hair colorist in business, because those are the ones that make you go gray. Because that's an incredible pressure to put on a person's shoulders. But we take it.
You talk about the system working and the adversary system. You've got a good lawyer on the other side. So I'd like to ask you a question I didn't warn you I was going to ask you. I tried to let you know ahead of time, but it just occurred to me. I think the students would be interested in your response. In all these years of doing this, have you ever had occasion where the prosecutor wasn't doing such a great job, that the prosecutor maybe made a mistake of some kind that you could take advantage of to the betterment of your client?
Oh, sure.
Okay.
Sure, but...
Now, here's my question, okay? All
That
right.
was
Well, here's my next question. Do you have any hesitation about taking advantage of the mistake of another lawyer?
Well, I have a hesitation adopting your phrase.
Okay.
your term, taking advantage.
Well, okay, fair enough.
Yeah, that denotes that I'm somehow, it just sounds icky, it sounds dirty.
All right,
It
well,
sounds-
let me,
It sounds-
let me rephrase it, because I don't mean for it to,
Yeah.
I was trying to just make it vivid. It's not a judgment at all, because we all know lawyers in adversary situations routinely take advantage, quote unquote, of the other lawyer's mistakes. I mean, that's just the way things work. I want to hear you talk about why it's unfair to characterize it as taking advantage.
Well, because first of all, if opposing counsel, as a prosecutor, makes a mistake in the law, then I have an ethical and professional obligation to clear it up with the court. I mean, if the U.S. attorney, if we're at a plea hearing and the district attorney says, here's this, he's pleading guilty to, I don't know, bank robbery. And Your Honor, the and the judge says, and what is the sentencing range to her? And she says, it's 0 to 20, Your Honor. And I know that the sentencing range is a mandatory minimum 10 up to life in prison. There's no advantage to that. I'm going to say, well, Your Honor, that's not correct. It is a mandatory minimum 10 up to life. But I'm going to tell you why I want you to deviate from this or whatever, or why we're seeking 10. I'm not going to let that mistake, because that's just my obligation, and that reflects on me, and it's just wrong. I mean, that the system has to operate, even if the judge is wrong, I have to tell the judge, even if the judge thinks he doesn't have to sentence him to 10, I have to say, well, Your Honor, I have to tell you, here's the statute. As much as I wish you were right, you can't. You can't sentence him to 5. But certainly I have had cases, and maybe this is why the taking advantage maybe it's well, I'll let you decide what it is. I'm not going to characterize it. I have been practicing for quite some time now, and that means, as many of you know, the district attorney's office is a wonderful educational training ground. It's like in medical school where residents are in there. I think they let them operate on an indigence or something, isn't there? Here's a good appendectomy. The guy's got stage 4 cancer. Take out his appendix, and even if you screw it up, he's a goner anyway. So I don't know. I'm guessing that's how it works. I could be wrong, but something like that. So the district attorney's office is a good breeding ground for a good place to practice trying cases. It was wonderful for me. I was trying them back to back to back to back. And you start out with smaller felonies, so that if you screw it up, if you screw up a felony shoplifting, all right, you pretty much got the job done anyway, because you put this person through the rigors of an indictment process and a trial. But then you're just practicing learning how to try a case. So, if you've been practicing 20, 25 years and you're up against a very young prosecutor, you're going to think, geez, I wouldn't have done it that way, or I wouldn't have said that, or I don't ever want to embarrass a young prosecutor, but I do want to call to the jury's attention things that they do that are wrong that will be to my client's advantage, because they are the power of the state. They get an enormous amount of power, young assistant district attorneys, with sometimes very little maturity level and very little oversight, and it's a shame. So I think that's an important part of my job, but I don't do it in a way to embarrass another young lawyer. I mean, it's important to me to be a mentor, and I do mentor a lot of them. But I got a client who's on the hook for prison, and I got somebody who wants to put him literally in a cage for X number of years. You got to do it all right, and if you don't do it right, then I'm going to point it out.
it's interesting, you can translate what you're talking about. I think, and the students, I hope, are doing that in their heads, is think about that sentencing question, that your duty to the court really is taking precedence. Yeah, and that in the other situation, your duty to your client is, and at the same time, you're not being nasty about it, you're being civil about it, but you're still going to act to the advantage of your client. So, interesting. I'm going to turn it to the students in just a minute. I want to ask you really just two other things, I think. You're in the private practice of law doing criminal defense. About 80% of our criminal defendants are indigent and are represented by appointed counsel. Where does your business come from? How do you get clients?
The biggest source for a number of years of our clients were attorney referrals, lawyers who do other things besides criminal defense. And so being involved in the Bar Association, the local Bar Association, and other social organizations, so that you develop this friendship, collegiality, and professional respect, so that if a lawyer who does real estate closings gets contacted by a person who he just closed a house for, to say, my son just got arrested for beating up his girlfriend, what would you help us? Because folks usually just know one or two lawyers. Then he would say, oh my God, I can't help you, but let me give you Laura Hogue's number. And I highly recommend that you talk to her. That was the bulk of our business. I think now as we track it, it's been an interesting and odd shift after about year 20. And that is that we would always have the receptionist, when someone would call and say, I'd like to speak to Frank Hogue. The receptionist would say, oh, I'd be happy to connect you. Can I ask you where you got his name? And it would be, the internet, or another lawyer sent me, that kind of thing. Now, it's just, they just know who he is. And that was a shift that came after about 20 years. And it isn't because we don't advertise, the public immersion, the exposure is just that criminal law kind of does that for itself. These cases that we do are always in the paper, always on TV, always on the news in the morning, the radio as you're driving to school or to work. So the name gets its own amount of saturation. But then you got to get money from the people who know your name. And during times of economic downturn, that's a little bit harder. But you can be a little more creative. People don't necessarily have the kind of cash on hand, but they might have property that they're willing to divest themselves of in the name of helping out a loved one. But in criminal defense, you have to have all of your fee arrangements made up front, in full, I highly recommend, before you ever enter an appearance in a case. Very different than personal injury, for example, where there's a contingency fee and there's contingency, you don't have to pay anything up front. If you are banking on the promise of payment later on in a criminal case, you will not be able to support yourself. And it's hard to do. It's a very hard thing to look at a crying grandma talking about the grandchild she raised from birth, gave her whole life up for a whole nother generation of a human being because her kids weren't taking good care of him. And he cannot stay off meth. And she's crying because he's now been arrested for selling it and just begging for your help. And before I can help him, I have to have her pay me. And it's a hard thing. It seems cold, and in the beginning it was really hard for me. That was the biggest change. It wasn't philosophical, moving from the DA's office to private practice. That was not the hardest part. It was the business part of it. It was the fact that no one's directly depositing a check into my account every month. Even though it wasn't a great big check, it was there every month, whether it's on vacation or trying cases. But in criminal defense, in private practice, I have to find a place where the money isn't dirty. Meaning, I don't mean it that way, where getting money for what I do doesn't feel dirty. And I don't know why. And I think women have a harder time with this. And maybe you all are young, much younger, and you're probably much more professionally savvy than I was when I started law school and started practicing. But we might have more of a, we should do this because it's the right thing to do kind of thing. And the fact is, I've found a way to be able to say, look, I have a team of people. I support families because I have a receptionist who has a child and a husband, and I have a secretary, and I have a legal assistant, and I have 2 associates, and I have a research and writing lawyer, and I have people who take care of this building, and I have to pay Georgia Power, and I don't want to think about whether I can do all those things and maintain those obligations. I've gotten to the point where I have earned the right to say, you're asking me for my services, and they come at a premium, and this is what it costs. And if you cannot pay that or don't want to pay that, I have no less respect for your commitment to your family, your love of your grandchild. It has no reflection on that, none whatsoever. So this is purely a business thing. Can you pay what I need? Not do you want to pay it, and I appreciate that everybody wants to pay it, but can you do it? And if you can't, then I have to encourage you to talk to the public defender.
Let me turn it to the students. We've got about 5 or 6 minutes left. I want to make sure they get a chance. I didn't even get halfway through my list, but that's good. What questions do you all have for Laura? Yes, ma'am.
You made a mention of the publicity and in light of your husband representing Stephen McDaniel trial and his murder. Do you have any advice for us on how to prepare, or how do you prepare for media attention when you're dealing with high-profile cases?
For purposes of the recording, the question is, how do you deal with the media and prepare for dealing with the media in a high-profile case?
Okay. And I just want to, just as a side note, I don't think that I mentioned Stephen's case, but perhaps that's what would come to your mind, and I understand that. The reality is that criminal cases, violent criminal cases, and sexual criminal cases attract the media like, I don't know, use some analogy, whatever the common analogy is, but
Bees to honey.
Bees to honey. And you have to establish your own rapport with the media. My husband, my law partner, has a wonderful rapport with the media. And he does a very good job of advocating for his clients with the media. I don't do it as well as he does. And part of it is that I had some experiences earlier on where I felt as if I had made the mistake of thinking that my conversations with the reporters would necessarily look the way, like my in the paper or on TV, like my conversation with the reporter. When in fact, they're just going to pull the snippets from it that are the best for selling papers or TV time. And so I felt as if I had made some mistakes earlier that ended up in me appearing as if I was trying to use the media as a sword instead of a shield. So I went for a very long time, and the reporters now have joked with me about it, where I didn't comment. I just plain didn't comment. And I think I went too long, in retrospect. But now I do comment, and mostly because if the state is commenting, and I'm not commenting, then it's leaving my client in a public way unprotected, or at least uncomforted. So, there's some pat things you can say. I will never do this, and lawyers disagree with me. I will never at first appearance hearings or bonds, or I'll never be saying, we didn't do this, and he's completely 100% innocent, and we're going to be fighting that. I don't say anything like that, because usually you don't have a clue about the case. And I just don't ever want to have been recorded one day saying, we're just mortified at these charges. And then 16 months later to be recorded or to be in front of a court at a guilty plea saying, Your Honor, I want you to take note that he's accepting responsibility and he feels awful about this. He's been wanting to do. I don't want to be that guy. So I think for your business, you do need to comment. And here's the part of it part of it is you just got, if your name's in the paper, it doesn't much matter. Carl Westmoreland used to say this. He was a big divorce lawyer. It doesn't matter what they're saying about you, just so they're talking about you from a publicity standpoint. But I would keep in mind that you cannot use the media to accomplish any of the goals in your case. All you can do is to just have a presence there. And again, if Frank were here, he might have a very different way of dealing with this question, but every lawyer has a different approach.
We've got time for one more quickly. We've got about a minute to go, Laura.
When you were talking about dealing with clients that, not deciding on whether you think that they did something or they didn't, is that something you had to unlearn in the very beginning? And if you did have to unlearn, making that decision right when you sit down, how did you do that?
No, I think it was a protective wall that I very quickly put up. Because when you prosecute, that is exactly what you have to do. You're the one who decides. You have a professional obligation to decide whether you believe this person did it. Because you cannot present a case to the grand jury or prosecute a case. You have a professional obligation to dismiss a case if you personally don't believe that the crime was committed by this person. So it was such an enormous switch that I think it's a wall I put up, that I rarely think about my own personal feelings about whether the person did it as some stumbling block to my advocating for him or her.
I wish we had more time, Laura, but we don't.
No, we're fine.
All right. Join me in thanking Laura for being